Hello, in this video I want to talk about children and looking after the needs of their children. I came across a PDF from a company called Brabner's in the UK, UK solicitors, and I was reading through it. So I'm going to, for the purpose of this video, read through their information, and I'm also going to add in some of my own or ideas that might help you prepare when you're getting ready to negotiate how the children are going to be looked after once the divorce has been finalised. Hello, my name's Elizabeth Goddard from the Divorce Sanctuary, and on this channel I talk about healing from emotional abuse, divorcing both physically and emotionally from the abuser. If you're new to the channel, please don't forget to like and subscribe and share the video. And if you're returning, welcome back and thank you. And thank you so much to all my new subscribers recently. It's just amazing. Thank you. So in this video, I wanted to talk about children and looking after their needs. And I came across a PDF called Looking After Children When a Relationship Breaks Down. I'm going to read from it, but I will and have tweaked little bits here and there, which I will highlight. Relationship breakdowns are difficult for everybody involved, but more so for the children. And I remember reading a book many years ago when my children were very small, and it compared the reaction of the people around the family and the family unit when it broke down. And it was saying that if a parent had died, the reaction towards the children was different to that of divorce. The reaction from friends, family, and even the school is that a parent is still alive, and therefore not as life-changing as the death of a parent. And this is not true, because for children, they have no understanding, can't quite comprehend what is going on. And remember that decisions you make now are crucial. The UK courts take a hands-off approach, so it is really down to you to make the arrangements for your children. And when you are dealing with an emotionally abusive person, you really need to think of absolutely everything. If you can reach an agreement, the courts won't get involved. They'll just cast an eye over the paperwork. Now, I've taken this information or the following information from Brabner's, and I'll put the link below to the PDF that I'm working from. And I will also put below my workbook from Broke to Broken, because in the back of that is a sheet that I talk about later on. So what should you include in the arrangement? The nature of your arrangement depends on your circumstances. There is no blueprint. It says it's just about whatever best protects the interests of your children. So personally, I would make sure that you've thought about the children as they age and about their needs. A child at the age of 5 has a very different needs of that of a 10-year-old and a 15-year-old. So when you're thinking about your negotiations, make sure you put breaks in place so that you can go back and renegotiate, and you can readdress it for your children's needs at their different ages. Emotionally healthy people want an agreement that works for everybody. Emotionally unhealthy people want one that either works only for them and their needs, or is the most destructive towards you. So put it in the agreement. You might not need it, but make sure it is in there, that you have a break clause or a renegotiation clause in place. And in the booklet, the next section is you'll need to ask the following questions. Who will your children live with? You may want your children to share time equally with both parents. However, there's no automatic assumption this will be the case, and this sort of arrangement doesn't often work in practice. Your children have a right to a relationship with both their parents, unless there's a very good reason to suggest otherwise. This means that the question of who your children lives with is very much down to how they spend their time with both parents. Also, what practical issues do you need to consider? You'll need to look at the day-to-day issues. Ask yourselves key questions such as who lives closest to your children's school? What hours do you both work? Who has the time to do the school runs? Who did what on what day-to-day basis prior to the separation? By doing this, you will come to the right conclusion about who is best placed to look after them at what times. You may want to ensure your children spend meaningful time with you and your ex-partner. This might mean alternating weekends, sharing responsibilities for extracurricular activities, and considering how best to ensure your children maintain strong relationships with their wider family. You may need to make different arrangements for your children in non-term time. A weekly or fortnightly timetable works well when the children are in school, but it won't allow your children to share school holidays with both parents. So it is best to decide this now to avoid conflict later. Also, you'll need to consider who will look after the children on special occasions like their birthdays. And also, what happens if you disagree? Mediation is an option, but it can be very frustrating when your estranged partner is playing the victim and part of you is screaming inside, can't you see what they're doing? You know what is best for your children. Ask your estranged partner to put down their ideas of how they believe it will work. You can also create a list. If you go back to the negotiation list that you created and sit down as this as a separate entity, what is the ideal scenario? What is non-negotiable? And what are you prepared to be flexible on or to give away? I didn't have a break clause in the agreement with my ex, and he was not wanting to renegotiate. His children were unhappy and frustrated, but he fixated on the agreement. This meant that every Mother's Day landed on his weekend. And so what we did was on a Sunday evening, we would celebrate when they came home. Sadly, there was no flexibility on his side. Our original agreement was changed from them seeing him one evening a week and every other weekend to just every other weekend, as he had commitments. And when they were getting older, into their teens, there were months where they didn't see him as he was busy. In his eyes, this was what I had wanted, and therefore, if I had asked for an amendment, it couldn't happen. But because he was asking, we could. This is why it's crucial that you get them to do the negotiations, them to put forward their ideas, and them to tell you what they are able to do and negotiate from there. One occasion, I'd been training for a marathon or half marathon for months, and the weekend before, he advised me that he then had an event and he could no longer have his daughters. So it was down to me to arrange for someone to look after them. Make sure that it's in your agreement who is responsible for doing that and what conditions you want to put in around that. Think about who they are likely to use if it's their responsibility. Do they have responsible family members? It might be really frustrating for you, but would you rather know who is looking after your children? And would you prefer to organise that yourself? For me, this was a weekend that I was going away for, and it was frustrating for me to be put in this position. It's something that I'd spent months and months training for. However, I knew where my children were. I knew who was looking after them. You can create a memorandum of understanding, and this is a record of arrangements you and your ex-partner both intend to make for your children. This document isn't legally binding, however, it is a strong record of intention. It gives both parents a framework to work around, and it sets out what you did agree should they ever unravel and end up before the court. Personally, I don't see how mediation can work with an emotional abuser, manipulative person, but I am told that it can. So have your list ready, know exactly what the needs of the children are, so you can stick to those. You can keep bringing the mediators back to the needs of the children. That's the most important thing. It was the one thing that I found when I went through mediation, it was monopolized by, what's my new word, manipulated and monopolized. They monopolized the conversation, manipulated the conversation round to them and their needs. And it was all about the children. We needed to bring it back to the needs of the children. So if you need to get the courts involved, you need to apply for a child arrangement order. You can use this to agree in writing where your children will live, how much time they will spend with each parent moving forward. And apparently there are two types: a shared care order, and this doesn't always mean an equal division of time, and a lives with, spends time with order. You will have the opportunity at various points throughout the process to reach an agreement with your ex-partner. But if you're not able to do so, the court will ultimately impose an order upon you. Another thing to put in is how you're going to make important decisions. And again, the court will have expected you to do this as parents, to make important decisions which impact your children's upbringing together. And nowadays, both parents generally have that parental responsibility. It means that both of you hold equal rights, duties and responsibilities in regard of your children. You need to work together with your ex-partner to decide things like which schools your children will attend, what type of medical treatment they will receive, what religion they will follow. Again, if you can reach an agreement that works for both of you, the court doesn't need to get involved. But if you can't, then you need to apply to the court for a specific issue order or a prohibited steps order to determine how these issues will be dealt with. And there are other things that you need to consider. There are various issues that arise following the separation that you might need to take into account. One of those is relocation. What if you or your ex-partner want to move away, perhaps for work or to be closer to family? You must decide whether your children will move or will remain with the parent that they live with locally. And relocation cases can be really difficult for everyone involved. The decision comes back to the best interest of your children. But there is a specific law that must be applied in these cases, and it requires a great deal of thought and consideration. What about your working relationship as separated parents if it breaks down? And this does happen, and it does have an impact on the children. In these cases, the court's involvement is often inevitable. The court cases involving children have some level of involvement from CAFCAS, which is the Children and Family Court Advisory and Support Service. But those in which the parental relationship breaks down to the extent that it creates risk of harm to the children will usually have ongoing CAFCAS involvement. They will take a number of factors into consideration, not just the risk of physical harm from that situation, but also the risk of emotional harm. Sometimes one parent will try to prevent a child from having contact with the other, or even go as far as attempting parental alienation. And none of these things are the best for your child. But these things do happen, and in these cases it will fall to CAFCAS to provide recommendations to the court, which will ultimately determine your child's future. Also, you need to consider financial decisions. Can you ensure your children are provided for financially? The first issue is basic child maintenance, dealt with by the CMS, the Child Maintenance Service. This is paid by one parent to another and is calculated by the paying parent's income. In cases where there is a higher income, if you are the recipient parent, you can apply for a top-up maintenance over and above what is payable by the CMS. under Schedule 1 of the Children's Act of 1989. Schedule 1 also allows the court to make orders for lump sum payments or settlement of property for the benefit of your children. And in some cases, you may also want to put in place an order which allows one parent pays for a child's nursery or school fees. Also consider talking to a refuge. These charities have a huge bank of knowledge and advice. They don't just help people escape from abusive relationships, they are able to support you as well. Think about these things when you're trying to reach an agreement. Where your child is going to live or your children are going to live. When they will spend time with the other parent. What you will do around issues regarding schooling and medical decisions. Also think about nursery and school fees, school trips. Each stage of a child's school life comes with financial challenges. Think about college and university. Make sure that there's a clause in the agreement that the financial support is until the end of their education. And as I said, I'm going to put the link below to my workbook. Broken is my superpower. In there is at the back is a form. Start working through it. You can change the headings maybe and start thinking about just your children, how you're going to support them and what they need, their needs within visitation rights, how they're going to spend the time with their extended family and with your ex-partner, how you're going to do the handover, how you'll think of absolutely everything. At the back there are 3 columns and you've got non-negotiable things that you're not going to move on. Mother's Day, Father's Day, Christmas Day, other holidays that there are, summer holidays, Easter holidays, half terms. What are you going to do? Get it all down on paper and ask your ex to do exactly the same so that you can come together, or you can use some form of negotiation to come up with an agreement that works for everybody. But the focus has to be the need of the children. I remember speaking to my ex-husband a few times, with trying to renegotiate with him and trying to get him to understand, but he was so fixated on the agreement and it had been my decision. At the time, this was a common theme every other weekend and a day during the week. But because it was my idea and I had put this forward, it was seen that this is what I wanted. And it clearly wasn't working years later, but the fixation was that it was me that had done this. Please sit down and look at the needs of the children. I hope you found this useful. I will put the links from the website that I got it from, and I will put my workbook, Broken being your superpower, and I'll also put a link to self-care, because you might find things in there that you can create environments for your children to support them as well. I will also put the links to both my books, Finding Lily and the A to Z of Emotional Abuse. I hope you found this useful. I'm sending you loads and loads of love.